natural person give an invoice to the club.
Can we go back to the previous slide?
Yeah.
Just to add something. Basically, because Márton mentioned Swiss law, to tell you that under Swiss law, as opposed to the FIFA agent regulations, you have two types of activities that are inherent to a licensed agent. Because Swiss law treats agents as brokers, they have either the opportunity to point to another opportunity to sign a contract, so they are not involved as direct intermediaries negotiating the deal. They just create the contact between the client and the buyer, or they are the negotiator, they are the intermediary, and that's how they make their fee. And as to FIFA regulations, you have a variety of services, including even tryouts sometimes.
Exactly. So that's why we also described here on the service boundary things that you might do, and then also, which comes to the next slide, what does the company actually do? What do your colleagues do that you work with? So you as an agent, per the FIFA rules, should be the one who negotiates, who approaches clients, who starts negotiating, talks to clubs, who basically arranges the deal. But your company and your staff, it could be your assistant, it could be a secretary, it could be somebody else, they also need to do certain things and take that burden off you. So what they can also do is they can help you with the administrative matters, with the finance, with the logistics, things that you generally might not have time for, but your client might also seek your help with. And then, what do? How do you enter into the contract, right?
Before we go there, let's give them some practical examples.
Okay.
For example, let's take Krasi, for example. Krasi is my head of agents in Sila International Lawyers, but as a CEO of the company, I'm the one who's signing the contracts. And according to the FIFA agent regulations, I need to have a FIFA agent license. If I don't, I cannot sign the contract that's under the FIFA regulations. I should empower Krasi with the power of attorney to sign on my behalf. So this is kind of making things more complicated, and that's why I had to get a license for myself. Same applies to Christo, who is a CEO and a FIFA agent of a big sports agency, and he also needed the agent license so that he can facilitate the work of the agency that he runs. Otherwise, he needs to empower other people to sign those agreements. So what is common nowadays is that we have owners, shareholders, or owners of agencies that are not licensed agents, but yet they make the photos, they make the medium, and everybody knows them by face, by name. But behind their work, there are other people who are licensed, and they actually legally deal with the contracts and the bureaucracy. Let's put it simply.
Absolutely. Yeah, and so that's the question which Georgi will further get into in a second. But then, how do you put yourself into the contract? In the very beginning, we were a bit nervous that, well, the license belongs to a natural person. So at the start, it was, no, it's just going to be me, Márton Kiss, and then that's it. Then you...
And that's also problematic in terms of the FIFA regulations, because the FIFA regulations are saying that if you lose your license, the counterparty can terminate the contract with just cause. So it's inherent and directly linked to the holding of a license, the validity of an agency agreement.
Exactly. But if I need to invoice, I will put Márton Kiss, who facilitates his work through Sila. But that doesn't solve this problem. So then, okay, I put Sila, represented by Márton Kiss. But as Georgi already said, I can't represent the company. So then I put, okay, Sila, and then the license agent Márton Kiss, and then signed by the CEO, Georgi Gradev. So it creates, well, I wouldn't say mess because we can organize it, but at the end of the day, these are things that later, which Georgi will explain now, can create issues specifically when you come to the enforcement and you're trying to get your money.
So you have three options. You have option A, where the agent is the sole party to the contract on the side of the agent. Of course, you have a counterparty, which is the client. But on the side of the agent, you can have option A, only the agent, as a natural person. He's the one who, or she's the one who holds the license. We have beautiful ladies here who are licensed agents as well in the room. So this is option A, but sometimes it's not comfortable. I don't know how you organize your work. I assume that you have a company and you're using it as a vehicle for administrative, financial reasons, right? Is it correct? So then that's the second option. The second option, you do a contract between your company and the clients. Of course, you are representing the company on that contract. You are a licensed agent. Maybe you're a CEO, maybe not. It's not so relevant for the purposes I'm speaking about. So that's the second option, where you have a company on the one side, on the other side you have the client. But sometimes it's not very producive. Because what will happen if you lose your license? Will this contract with the company expire, being terminated? No, because the company doesn't have a license. So you're not entirely within the legal framework of FIFA. And the third, more common option nowadays, for me, and not only nowadays, but also in the past, is when you have both the agent and the company together as two independent parties on the side of the agent that are signing the contract. So basically, this will require a very clear stipulation on the header of the contract that this is the agent, the natural person who acts in his own name, and on behalf of the company and the name of the company. There is a very old cast award on Pini Zahavi, one of the leading agents in the world, with his company Go Limited and Besiktas, where the cast panel made it very clear, be careful whom you put as a party to the contract. Is it your company, you, or both of them? If you want to have both of them, you need to use words such as on behalf of, together with, and. This actually keeps both the company and the agent as parties. This is important because later on, when you don't get paid, you should know which party has the standing to claim, which party owes the right to claim. And sometimes when agents are signing with their companies, particularly in the past, and going to claim as agents, FIFA and CAS were denying jurisdiction, saying, I'm sorry, but you're not a party to the contract. And the agent comes and says, but I'm the only shareholder in my company. Yes, but still it's a company, it's a legal entity. This has changed a little bit under the new FIFA regulations. There is a specific document called Questions and Answers to the FIFA agent regulations, which for the first time clarifies that FIFA will follow the practice of the Basketball Arbitral Tribunal, where they actually equate the companies, all by the agents and the agents themselves. So no matter which of the two will claim, they will have standing to claim in any case. But from the perspective of civil law, it's important to clarify who gets the profit on the contract. So for example, if you're using the company only as a vehicle, administrative, financial vehicle, to do the invoicing, to do your email correspondence, to do the accounting, then you have to be clear in the contract who gets the money. Because if it's the company getting the money, then it's the company who has the standing to sue. This is the party that can go to court and get the money. And then the next question which will arise in your heads is, okay, I'm a licensed agent. I can go to CAS, because FIFA is blocked right now by the court in Dortmund, and I'm going to have a case on behalf of my company against my clients. And when I win, it's the company who wins, and I need to collect my money. What I'm going to do next? FIFA is regulating me as a licensed agent only as long as I'm a natural person. But now I have this agreement with my company. Even if I'm a party to it, the money goes to the company. What can I do? The recent practice of FIFA is as follows. Once your company wins the case in CAS, generally in ordinary proceedings, first instance proceedings, because you cannot go to FIFA at the moment, you can go to FIFA as a licensed agent, and you can prove to FIFA, because even now the legal portal is designed in a way where you can submit an evidence that either you're the shareholder, or you're the CEO, or you are empowered by a contract or a power of attorney to collect the money from the counterparty. And FIFA will start an enforcement proceedings under the disciplinary code on the name of the licensed agent and not the company. And in the past, with Márton, we had to do some assignment of claims. The company is assigning the claim to the agent so that the agent can go to FIFA and claim. Nowadays, this is not necessary anymore. What I'm saying here is that you should not be afraid of bringing your company as a sole party or as a second party to the agreements you sign. In any case, if you win the case as against your client who is not paying you as a company, when you go to FIFA to execute, to enforce the CAS award, you can do this as a natural person, even if you're not a party to this agreement and only your company is a party to this agreement. We had the luck with Márton to do the first case ever. Since then, they changed the legal portal, and now you have this specific section where you can upload the document, providing that you are somehow empowered to get the money from the company. Okay, we spent too much time on that. Marty. Yeah, okay. Now, you see, in agent parlay, we have always interchangeable terms such as letter of authorization, mandate, representation agreement. Among you, I'm pretty sure nobody knows the difference except my friend Sal, because he's a top sports lawyer from Italy. And I want to make it clean for you what is what when you use one or the other. Of course, FIFA doesn't help with that. Let's start with the mess that FIFA creates first with their regulations, and then we will go to clean this shit. Sorry, my French. FIFA is regulating only representation agreements, right? You know the rules. Most of you are licensed agents. But they say something. Okay, they put a lot of limits in this. They say your representation agreement cannot be for more than 2 years. You cannot be remunerated by every party. You cannot represent minors if you don't have an authorization, if you don't go to do A, B, C, D, E, F, G. You're not going to be licensed anymore if you don't do this and that. Your representation agreement provides for obligation to do this and that to your clients. As a separate agent, you cannot poach clients from other agents unless 2 months are left on the contract. So there are thousands of limitations on you as licensed agents and having representation agreements or not having representation agreements but want to have a representation agreement with someone. And at the end of the day, you have signed a 2-year representation contract with a promising player to represent him worldwide in non-specific transactions. You can move him every 6 months somewhere else. And you have a problem, and you go to FIFA and they say, oh, I'm sorry, but since your contract is of general nature, for non-specific transactions, we don't have jurisdiction. So they're putting you in a box with a lot of limits, and at the same time you get zero protection from FIFA. And they also get your money, because you have to pay an annual fee of $300 every year. And you have zero protection. Even if the agent chamber was operative or the disciplinary committee was working, and they are not because they are suspended since 2023, you still have zero protection. This is bringing me back to the question of representation agreement. They say that FIFA would have jurisdiction only if 2 conditions are met. First, the player you represent, or the club, whatever, is involved in an international transfer. This means that a coach or a player is moving between different national associations. That's clear. But the second condition, which is disturbing me, is that it has to be related to a specified transaction, which means that you need to put the exact names of the parties involved in the transaction. I'm moving Hristo from Real Madrid to Peter in Omonia Nicosia, and I put the name of Hristo as a player, of Real Madrid as a selling club, and Omonia Nicosia as a buying club. And this is an international transfer with with determined parties. Only then FIFA would help you if something goes wrong. But if I have a general representation agreement with Hristo over 2 years, and I'm moving him from place to place and he stopped paying me, I can't go to FIFA. So basically, this shows that there should be a differentiation between the different types of agreements. So we have actually 2 types of agreements. One is a mandate, which in terms of civil law, and particularly Swiss law, is exactly what FIFA calls a representation agreement for a specific transaction. Mandate is a simple agreement which is dedicated to a specific transaction. In brokerage terms, this is what you give to your broker to sell your house. Sell my house. It's valid for the term you sell my house or for another term we determine in advance, and I'm paying you only for this transaction. But once the broker has done his job, he's gone forever, you sold your house and you don't care anymore about this broker. So that's what FIFA is actually trying to tell you, that you have to have in place in order for FIFA to interfere within their jurisdiction, and you can be protected by FIFA. In the general scenario, when you have a representation agreement, which is with general terms, no specific clubs to move your clients to, no specific transactions over 2 years of period, this is the term of a representation agreement coming into play. So there is a general distinction between mandate and representation agreement in law. Not so much about FIFA, but as you see, when it comes to jurisdiction of FIFA, they also differentiate between the 2 types of agreements. And finally, we have authorization letters. This is equal to a power of attorney. In a power of attorney, rarely you see some terms between the lawyer and the represented person. Normally, they are agreed in a separate agreement, which we call engagement letter. Here is the same thing. You have either a mandate or a representation agreement with the player, but you need just a simple letter of authorization, which is a unilateral act. It's signed only by your client. You don't need to sign the letter of authorization, which you show to the counterparty, to the club. Say, look, I'm empowered to do the job for this guy, so you have to deal with me. But the terms and conditions agreed between the agent and the client remain confidential at all times. So I hope I made it clear. Marty, on to you.
Yeah, there's not much more to add. The only thing that you have to bear in mind is that once you understand what you're trying to sign with the guys, you have figured it out, you have called us, and you listen to our monologue, then you also have to understand that before you act, you need to have a paper. And here is where a lot of the issues come, because agents will come to me with a 3-sentence thing and said, hey, I'm authorized. Yes, you can have authorizations, but that's more just an authority to act. It's a power of attorney. So what we have done often is that if there is like a representation agreement, either version, we make them a 1-page letter that they can provide to clubs saying, yes, I have an agreement, the player signed it, it's explicit, just so that you may, if you don't want to, you don't disclose those terms that you agreed with the player. So, you
As
have
a follow-up to what you're saying, what could be the case if the player is, like Marty said, it is a common case, the client doesn't want to sign in advance? Okay, the FIFA regulations are clear. You cannot act for a client without first signing the client. But we know that in practice this is not working like that. You agree with me, Felipe? All right, so he's saying, I'm not signing, she's or he's saying, I'm not signing until you get me an offer. But you as an agent need to show something to the club that you're actually the person representing the client, right? So the player could agree only to sign a letter of authorization for you, which normally is linked to another agreement, but you don't have this agreement. So you have only the letter of authorization. What I can encourage you to do, at least in this letter of authorization, put an arbitration clause. When FIFA being operative, you can put FIFA. For now, CAS, the Court of Arbitration for Sport in Lausanne, is the best thing. Why is that? Because even a simple letter of authorization under Swiss law is equated to a mandate as a brokerage mandate. So in Swiss law, if you haven't agreed on any remuneration, that's not a problem. That's not an essential element of the agreement, as opposed to the FIFA regulations, which require that you have a remuneration to be valid. In Swiss law, you get paid either based on a tariff schedule, if such exists. We know in football it isn't. So the other option is as customary. What this means in CAS practice is, for example, if your letter of authorization is to conduct negotiations with a club for a player or a coach, you get paid for doing the negotiations. And the customary fee is 10%. It's not so difficult to prove that. But if your letter of authorization is just to point to an opportunity, to create an opportunity, meaning you put in touch your client and the club and you disappear, that's a less burdensome work you have to do. And in these cases, CAS is reducing the customary fee to 5%. We have a precedent, I'm sure Sal knows it. It's with Danubio, this favorite case we had. So this is what you can expect from CAS. If you don't have any agreement on remuneration, you can get 10% if your letter of authorization is for negotiations. If it's just to connect two people, could be 5%, even 3%, depends. But you need to have an arbitration agreement, arbitration clause in the letter of authorization so that you can defend your rights. So this is the least you can do if your client says, I'm not signing any mandate or representation agreement with you unless you bring me an offer on the table.
better move on.
Okay. Now this is really interesting for you. I'm pretty sure about that. I know I'm promoting my stuff, but okay, all of you are working with documents. And you know the paper trail is very important. All of you in this room who are agents have dealt with clients who are in breach of contract. They are not correct with you, right? You have also dealt with colleagues who are not correct with you. They're unethical, to put it simply, Abdul, right? Unethical. So I want to give you some tips what you can include in your paperwork with your clients to protect your interests in any case. and to draw your attention to the mistakes that many of the agents are making in dealing with their clients, and particularly when there is a breach of contract, what they do after to protect their interests. The first thing, of course, besides this slide, that you need to stipulate with your client is the scope of your services. You have to say what exactly you're doing for your client. Is it a negotiation? Is it just pointing to an opportunity, bringing him in touch with somebody, or it's tryouts, or it's training camps, whatever. So of course, apart from that, the legal part that's concerning me for the purpose of this presentation, the first thing you have to have is an exclusivity clause. So this exclusivity clause protects you as agent from other agents, from third parties. This means that your client, as a natural person, cannot talk and negotiate and work with other agents, but does not protect you from the client, him or herself. They still have the legitimate right to represent themselves alone without using your services. This is in the case of natural persons, when you have a football player or a coach. But the exclusivity clause in an agreement with a club protects you entirely. Basically, the club is stripped of the right to represent themselves without you. They cannot even go and sign without you. That's the exclusivity with legal entities. With natural persons, it's more difficult because it's interfering with their personality rights and the right to work. So they can always get to work and go against that prohibition. Sometimes Spanish courts, for example, there is a dubious jurisprudence in Spanish courts. Some are saying that a clause prohibiting a player from representing himself is valid. Others are saying it's not valid. But in any event, if you end up in CAS in Lausanne, even under Spanish law, given that the Federal Tribunal is above CAS and applies Swiss law, I'm pretty sure that any CAS panel will decide that such prohibitions are illegal. So the first thing you have to do is to ensure that you're exclusively the agent of the player and nobody will come to poach this guy from you. That's the first thing. What comes with the right is the liability. Being an exclusive agent to someone requires from you to be diligent, to have a loyalty and fidelity to this player. This means once you're exclusively entitled to work for someone, you need to work. You can't just stay at home and wait somebody to call that player, and the player comes to you, and then you get the commission. That doesn't work like that. In fact, the Swiss Federal Tribunal has decided in several cases that the penalty for an agent on an exclusive mandate who is not doing his job properly is loss of commission. So you're not even getting paid if you're not doing your job on an exclusive mandate. So, you know, with the burden comes with the right. So that's the first thing. I'll come back a little bit later with some practical examples to explain you how these clauses correlate between each other. The second one is probably the most important one for me, waiver of causation. The CAS practice, the football law practice, says that your job must be causal for the player signing a new contract or the club signing the contract that you are mandated for. So your job must be the reason why they sign a contract, your client signed the contract. You must show that. Otherwise, you're not entitled to a fee. Which brings us to a case, back to the case that where the player decides to represent alone. And he goes alone, you cannot prohibit that, you cannot stop him. And he represents himself with the club, no other agent involved, no breach, and you're not paid. But if you include a specific clause saying that you will be remunerated in any case, notwithstanding your involvement in bringing about and negotiating the deal, the Federal Tribunal considers these clauses to be valid. So this means you will get paid in any case, even if you're not involved, even if the player decides to hold you out of the deal. That's your guarantee that every time you're paid. And here, pay attention to the mistake most of the agents are doing. The agent disappears, the player disappears, maybe with another agent, maybe alone, you don't know yet, but he disappears and he negotiates somewhere with some club. Most of the agents are starting to pursue the new club and the player, threatening. You will be sanctioned. We will write to FIFA. We will write to the Holy Pope. You will see what will happen with you. We will stop your rights. You are not going to play anymore. That's not the case, guys. You have to chase the money. Follow the money. You have a waiver of causation, just follow the money. No problem. You want to represent yourself alone? No problem. Go, make the deal. Don't forget to pay me, because otherwise I'm going to sue you. I'm not involved. No problem. I have this waiver of causation. So this is a mandatory clause in any agent agreement to be on the safe side. Let's move on. Survival clause. It's even, this issue is mentioned in the Q&A document of FIFA. You have a 2-year representation agreement with someone. Let's say a player or a coach. And then within this period, you're procuring employment contract for your client, which will be valid for 5 years. Obviously, their contract will last more than your contract with the client. Do you have the right to receive commission after your representation with the player or the coach expires or not? If you don't have this type of clause, survival clause, you're not. The moment the representation contract with the player or coach expires, your right to collect fees from them also vanishes, because there is no legal basis for that. And that's exactly why you need a clause saying that even if your contract with the player expires, and until he signs a new deal somewhere, or renews the current contract, or terminates the current contract, you will still be remunerated for that period, because you are the cause for the player to receive this money after all. So you need to have survival clauses in order to be remunerated past the expiry of your contract with the player. And the final clause, which is probably the most important one in your contracts, is so-called liquidated damages or penalty clauses. Let's say first the difference, and then I will explain you the purpose of those clauses. Maybe it will come along. Liquidated damages clauses are meant to liquidate anticipated damages. This is covering your anticipated damage. In an agreement with a player, you expect him to, like, let's assume that we have a mandate, a specific mandate for a player to be transferred to a specific club. Let's say he's going to Rapid Bucharest. And in Rapid Bucharest, I have already know that they are able to pay me 50,000 euros as a commission. So I'm dealing with the transfer, and I anticipate 50,000. And that's why I'm putting in my agreement with the player that if he somehow breaches the agreement with me, he must pay me damages in the amount of 50,000. That's my anticipated damage. This is what I expect to receive as a commission from him. As opposed to liquidated damages, probably not opposed, but in addition to liquidated damages, penalty clauses are serving as an encouragement, as incentive to the counterparty to comply with the contract. It's not so much about what you anticipate to have as a damage. This is more like preventive function, not to penalize the player for a breach, rather to make him not to breach the contract with you. So you don't know what your anticipated damage could be, but you can still have a penalty clause in the agreement, which will actually encourage the performance of the contract correctly. And there is a difference in the case law between the two, which is significant in terms of reduction. If a penalty clause is grossly disproportionate, it's easy to reduce it. But with liquidated damages clauses, it's not so easy. According to the Federal Tribunal, they can be reduced only if there is a vast, huge disproportion between the actual loss and the amount of the liquidated damages. Only if there are a huge gap between the two, then the court could interfere and reduce them. So how they operate in practice before we go to the forum? Let's give you some practical examples. We have an agreement with the player where it says that I represent him exclusively. He must pay me even if I'm not the cause for the deal. And we agree on a, let's say, penalty clause of 50,000. What first of all need to be explained here is there are two types of penalty clauses. One is when they compensate the non-performance, which means that you're not interested in anymore in the performance of the contract. You just want your penalty. That's it, period. Another one is compensating for time or defective performance of time and place, which means I still want my money and I want my damages. And we spoke with, I think, with Abdul yesterday about that this second type of clauses, they're called cumulative liquidated damages. The first one is exclusive liquidated damages, is more appropriate for your contracts, guys, as agents. Why is that? Let's have this example again. I have waiver of causation. The player is leaving me. He goes somewhere, signs a loan. If that's the case, fine. I just ask for my money here. There is no breach of contract because the player representing himself. I'm following the money and I'm safe. I don't lose anything. But if the player is going somewhere else with another agent, and I have a proof of that, what I'm going to ask is first the remuneration, because I'm not involved in the deal, and second, I'm going to ask the penalty, which will penalize him for his behavior, because he breached the exclusivity clause by hiring another agent. So I can ask both. That's why it's important how these clauses are written in the contracts. That's why we have Sal, you have Márton, you have me. This is very important, whether this is penalizing the player in addition to the fee that you're going to receive, or you're waiving the right to receive any fee and you're asking only for the penalty. It depends how the contract is drafted. That's why it's important. And I want to give you a practical example which is very popular in Spain. And we have even case law on Spanish courts. This is a mistake that a lot of Spanish agents apparently are doing, at least from what I see in the Spanish court practice. In the exclusivity clause, here, they say, the agreement is exclusive. So far, so good. Then they have one sentence which says, the player must inform me of any offer received from another club, from another agent, from any third party that may contact the player with an offer. So far, so good. But what the clause doesn't say is that the player cannot represent himself without my involvement. It doesn't say so. That's how they draft in Spain. And we move directly here in the penalties. What behavior is penalized in these contracts? Since we have an obligation to inform, we as lawyers would anticipate that maybe the penalty will apply if you don't inform your agent. The agent must be informed of any offer you receive. So this is what you normally expect. Penalty if you don't inform. No, that's not what they do. The penalty is imposed if the player represents himself alone. But then there is no obligation for the player to fulfill. It doesn't say you must not represent alone. You must be with me. And there is no penalty here for not informing the agent. There is no penalty. So what could be the damage of the agent for not being informed? Nobody knows, because even if I inform you as an agent and I bring my offer from Real Madrid, I'm giving it to you and I'm telling you, I fulfilled my obligation to inform you, but I'm not using you. I'm going to represent myself alone. Bye. Nice to meet you. I inform you. But you had no damage if I don't inform you, because I can still choose not to use your services. So this is a typical mistake. Don't do it in your contracts. You have to have an obligation and a penalty for not complying with the obligation. They have an obligation and no penalty, and a penalty with no obligation. That's typical for Spanish contracts. So I think I made a very clear distinction. And finally, the forum. That's important. We will spend some more time in the next presentation to explain about the forums. But for the time being, FIFA is not operative. The agent chamber does not work. We have only CAS operating in sports law. So we can use CAS. We can use national tribunals, of course, when it's appropriate. And civil courts, which is not very appropriate in most of the time. But sometimes it's also an option. What could be the case if you have a contract which is currently with an arbitration clause for FIFA? There are two options here. Option A, the clause is not very clear. Sometimes they write by mistake FIFA or civil court. If there is a slightest doubt that the parties may go to a civil court, there is zero chance for arbitration. The clause is not valid for arbitration anymore. Arbitration is possible only and solely if the parties explicitly waive their right to go to civil courts. So when this clause is written in this bad way, you go to the civil court and you have no recourse to FIFA or CAS, zero chance. But let's say the clause says only in case of dispute, we will go to FIFA. Right now you have this agreement and your counterparty is in breach. What do you do? Can you go to FIFA now? No, because the agent chamber doesn't work. Is this a full stop? No. You can still go to CAS. You say, why? I said FIFA, no CAS. This is called, in legal terms, pathological clause. Here, if you go to CAS with such an agreement and such a clause, CAS will accept jurisdiction. And there is case law on that. Why? First, CAS they have two criteria to check, two thresholds. The first one is whether you waived your right to go to civil court and you prefer to take your case to arbitration. By explicitly granting jurisdiction to FIFA, CAS will assume that you want to arbitrate your dispute. So this first threshold, which is really high, is already overcome. Then the second threshold, which is really low, is to establish the correct arbitration forum. And that's easy. What CAS is saying, okay, you chose FIFA. There was even one case that the parties chose FIFA and UEFA, so it's the same. You chose FIFA. What is FIFA? FIFA is a sports international institution. They provide alternative dispute resolution within the legal framework of FIFA. So you want to have your dispute resolved by an arbitration forum which is competent on football law. Which other could be to substitute for FIFA if FIFA is not competent? CAS is very close. Why? Because CAS is a sports arbitration court. Both are based in Switzerland. Both are dealing with football cases. And this is exactly why CAS will retain jurisdiction. So you're safe. If you have this pathological clause for FIFA now, you're safe. You can go to CAS. Don't worry, you will win if you have, of course, grounds on the merits. So I would strongly advise you to use CAS as the sole forum for now until FIFA starts operating the agent chamber. And I think, yeah, and always remember, this is the conclusion, keep an evidence trail. Evidence could be anything, emails, WhatsApp messages, Viber, Telegram, Signal, anything. Instagram pictures. We have used, in one case, Instagram publications by an agency announcing the signing of a player from a Turkish club, saying this is our new client, we signed with him. He even shared this publication. At the same time, he had a contract with an Italian agent. So this was clearly a breach of contract. We went to sue the player, we settled. But again, this evidence helped us prove that the player is acting in breach of his contract. And why the penalty clauses are so important? Because if you don't have a penalty clause, guys, and somebody comes and steals your player from you, there's zero chance, okay, let's say 0.1% chance to prove your damages. In the only situation where you have already received an offer from the same club where the player later signed, and you were the first contact with this club, and throughout the way of the negotiations, the player just dropped you and held you out. That's the only case where you can sustain your damages. But if I'm agent for Messi, that's Messi, you know. If I'm agent for Messi, exactly, that's what I'm mentioning. And you look a little bit like the frontman of Prodigy, you know. I like them, and like you. So let's assume here is Messi, and I have an offer for Messi from Barcelona right now. Okay, I'm his exclusive agent. I have an agreement with him, and I have an offer on my table with PSG, but I don't know anyone in Barcelona. I'm not in touch with Barcelona. I have PSG for him, and I'm talking to him about PSG. Sau is a very tricky agent from Italy. He has good contacts with Real Madrid. With Florentino Perez, they drink this coca tea, you know. No, that was another case, sorry. Sau is poaching my client behind my back. He's talking to Messi directly and offer him, no, not Florentino Perez, Barcelona was another day. Anyway, he's talking to Messi to go back to Barcelona. Can I make the transfer of Messi to Barcelona if I don't know Barcelona? No. No, I can only offer him a PSG. That's what's on the table. So if finally Messi decides to go with Sau to Barcelona, I cannot prove my damage on the basis of what Sau has already negotiated for Messi, because there is no causal link between our actions and the damage I sustained. My damage could be only if I have started the deal with PSG and he continued alone without me. But I don't have any damage related to his work and to Barcelona, because if he was not existing, I would never make this deal. So that's not my damage. And the only way you can protect yourself, and this is exactly what the Federal Tribunal said, is through penalties. So any contract you have as an agent must have a penalty clause. And I think that's all for now. We can go on with the next one. Thank you.